Hello everyone, welcome to Unacademy's YouTube channel. The topic that we'll be looking today is all about constitution. Okay. Now in this topic we will look at what are the origins of constitutions, what types of constitutions are there, and we will look at in depth what are the different types of constitutions, differences between those different types of constitutions, and what type of constitution does Indian constitutions belong to. All these things we will look in this video. Before going into the video itself, let me give you a brief introduction about myself. My name is Aravind. I'm a B mechanical engineer. I have 3 years of experience in teaching UPSC. I've experienced all stages of UPSC civil services, that is prelims, mains, as well as in my interview. My specialization subjects include polity, international relations, as well as current affairs. Now, what are the advantages why you have to subscribe to Unacademy? One of the advantages why you have to subscribe to Unacademy is you get access to top educators. Top educators like Sudarshan Gurjar, Murnal Patel. So these are top educators in UPSC platform for the past few years. Now you get access to videos from these people. Not only that, there are two types of subscription platforms available in Unacademy. One platform is Plus subscription platform. Another platform is Iconic platform. Now these two are slightly different types of platforms, but regardless of that, if you are subscribing to either of these platforms, you get access to all the videos made by top educators in India. So if you get access to all the videos in both these platforms, what is the difference between Plus as well as Iconic subscription? Now, Unacademy's Iconic subscription was introduced recently because many students felt that personal mentorship program was needed in Unacademy platform. So keeping that in mind, Unacademy Iconic subscription platform was introduced. Now the purpose of this Unacademy Iconic subscription platform is this is a mentorship program where personal coach will be assigned to you for UPSC CSE preparation. Clear? Unless in case of Plus subscription platform, you get access to videos, but you won't get personal mentorship. But in case of Iconic subscription platform, you'll get personal mentorship who can guide through all stages of UPSC preparation. Now this coach will steer their work and effort into the right direction so that you can squeeze maximum benefit out of your labor. Now through this program, a learner can discuss his study plan, strategy, other challenges, and if your study plan is lacking or if your study plan is too vast, all those things, based on the experience of the mentor, he will guide you through all this process, because you preparing for UPSC is not an easy task. You require constant guidance from experienced people, and that experienced people will be provided by Unacademy Iconic platform. Now, coaches or senior fellows in Unacademy platform have taught UPSC for the past number of years, and they have expertise in UPSC examination preparation. Since they have this expertise and they know what are the mistakes that common mistakes that students make in UPSC preparation, they can guide you through this whole process very easily, and you can get more out of your examination preparation. Clear? Now, how is Iconic platform different from Plus? Now, to understand how it is different from Plus subscription platform, you have to understand the differences between teaching as well as mentoring. Now, Unacademy Plus is more inclined towards teaching, whereas in case of Unacademy Iconic subscription platform, it is more inclined towards mentoring. Now, teaching is all about knowledge, and knowledge is all about sharing. And Unacademy Plus platform facilitates that sharing process, where almost all top educators in India congregate and they share their knowledge to students throughout India. But in case of Unacademy Iconic platform, people from Unacademy platform will hone their skills, and based on their knowledge, they will guide you through all stages of any examination preparation, so that you get a personal as well as relational feedback from through every stage of your preparation. Now this mentor will act as an advisor to you. If you are making any mistakes, he will guide you through that. He will monitor your progress day by day. All these things will be provided by Unacademy Iconic subscription platform. See, Unacademy Plus involves lessons on subjects including a detailed lesson plan, methods of assessment, all those things. But in case of Unacademy Iconic subscription platform, Here, Unacademy coach will provide you practical insight on how to apply this knowledge in practice. Clear? Gaining knowledge in UPSC is the easiest part, but how to apply this knowledge in UPSC examination is the most difficult part. Now, this application part will be provided by Unacademy subscription platform through various mentors. Now, how can you subscribe to Iconic subscription platform? So, whenever you are subscribing to Unacademy platform, you'll be provided with two options, Plus as well as Iconic. Now, if you want to subscribe to Iconic platform, click on the button Iconic subscription platform, and then you have to pay extra for Iconic subscription platform compared to Plus platform. Now, what are the charges? What are this amount charged by Unacademy in Plus subscription platform? Now, this is the amount Unacademy is charging for Plus subscription platform. Now, if you look at the amount that is Unacademy is charging you, this is very paltry compared to offline institutions. On top of the meager sum that Unacademy is charging you, if you are using my code Aravind V, you get 10% offer on your subscription platform, subscription money. So, for example, if you are opting for 12 months subscription platform, you'll be paying around 36,000. If you're using my code Aravind V, you get 3,600 rupees as offer. So, instead of paying 36,000 rupees, you'll be paying around 32,400 rupees. So, don't forget to use my code Aravind V whenever you're subscribing to Unacademy subscription platform. So, that's all with introduction. Let's dive into the class itself. So before going into before giving an introduction about constitution, first you have to understand the concept called as state. So whenever I talk about the concept called as state, people will often confuse with the other state called as Tamil Nadu state, Andhra Pradesh. Now the state that I am talking is completely different from this Tamil Nadu, Andhra Pradesh. This is capital letter S state. This is small letter S state. Now this capital letter S state I am talking about is, there is a definition for that. This is called as a nation or territory. Nation or territory which can be considered as an organized political community under one government. So a state is a nation or a territory which can be considered as an organized political community under one government. So based on this state, which areas can be considered as state? India can be considered as a state. UK, USA. So these are all states. Clear? Now when it comes to origins of states, there have been number of theories as propounded saying that state has been originated by this method. There are a number of theories like divine origin theory, social contract theory, force theory, patriarchal theory. All these things are there, but most common accepted theories on origins of state include two things. Most commonly accepted origins of state involves two theories. Most commonly accepted origins of the state include two theories. One is divine origin theory. The next one is social contract theory. So these are two commonly accepted theories on how state has been originated. Now, if you look at divine origin theory, now this divine origin theory says that God is the most powerful being of all beings in existence. Now, God appoints king as his sole representative. Now, whatever king decides constitute as state, it will be called as states. So, king gets to decide which territory will come under his control. King gets to decide who will come under this particular state, and king gets to decide on who form what type of government he is trying to establish, whether it's an authoritarian one, it's a benevolent kingdom, all these things. So king is the sole authority when it comes to deciding what will constitute as state. So king is very powerful in this type of theory, in this divine origin theory. But if you look at this theory, now this theory is followed only during ancient as well as medieval times. Clear? This theory was followed during ancient as well as medieval times. Now, in the last 200 to 300 years, the definition of state follows along the lines of theory propounded by social contract theory. Now, this social contract theory, people say that for establishing a state, people will come into agreement with the existing government. The social contract theory says that people will come into agreement with the existing government and they will sign an agreement called as social contract. Clear? People will come into agreement with the government and they will sign a document called as social contract. Now, what does this social contract say? Now, this social contract will give the power to the government for governing the people concerned. This social contract will give the power to the government for governing the people concerned. Clear? Now, this social contract is the one which is popularly termed as constitution. Clear about the origins of constitutions. Constitution is nothing but an agreement between people and the government. Now, this constitution is the power given by the people to the government, saying that this government has the power to rule over this particular territory residing this amount of people. Clear? Now, according to the social contract theory, a state should have 4 entities. The first one is a state should have territory. Clear? So according to social contract theory, state is born out of existence called as social contract. By signing this social contract, state comes into existence. In this social contract, there are 4 things that has to be defined. One such thing is territory. The next one is this social contract has to define who will come under citizens. The next one is social contract should also provide for means of government, who will be appointed to rule over the state. All these things should be mentioned in social contract. The last one is this state should have sovereignty. Clear? The meaning of sovereignty is that, for example, if India is a country, according to the Constitution of India, India is sovereign. Now, what does the word sovereign mean? That means India can take decisions without any influence of outside countries. Okay, without the influence of countries like UK, USA, Russia, without the influence of these countries, India is capable of taking decisions on its own. So that's the meaning of sovereignty, taking decisions on their own. Now, if you look at the classification of Indian Constitution itself, our Constitution has been classified based on these criteria. Here, in our Indian Constitution, there are 22 parts. Now, these 22 parts have been classified based on the requirements of social contract. Take a look at Part 1. Now, what does Part 1 talk about? Part 1 talks about territory of India. Article 1 talks about which will constitute as territory of India. Article 2 talks about which states can join India. Article 3 talks about reorganization of existing states. So, Part 1 talks about territory which is required for state. Part 1 constitutes Article 1 from Article 4. If you look at citizens, it is talked about in citizens are defined in Part 2 from Article 5 to Article 11. If you look at other provisions concerned with citizens, there are other provisions like Part 3. Part 3 talks about fundamental rights. There is Part 4. Part 4 talks about DPSP. Part 4A. Part 4A talks about fundamental duties. Now, all these provisions, fundamental rights, DPSP, fundamental duties, these topics involve with relationship between citizens as well as government. Clear? The first one we have defined. The first part talks about territory. The next parts talks about citizens. In these 4 parts, the first part 2 talks about. Part 2 deals with defining who can be termed as citizens. The next 3 parts deals with the relationship between government as well as citizens. Clear? Fundamental right talks about what are all the privileges that the government has given citizens. Clear? Like right to freedom of speech and expression, right to life. These are privileges the citizens in a particular state can enjoy. And DPSP talks about the obligations of a particular state towards citizens of India. And fundamental duties talks about the obligations of people towards government of India, state of India. Okay. Now the next one is government. If you look at government in part 5, from article 52 to article 151, this talks about central government, that is executive, legislature as well as judiciary. From article 52 to article 151, it talks about central government. From part 6, article 152 to article 237, this talks about state government, executive, legislature as well as judiciary. And there is part 7. Part 7 talks about union territories from article 237 to article 242. Okay. And then there is part 9. Part 9 talks about local self-government, especially rural areas. There is part 9A. It talks about municipalities. So, if you look at the classification itself, Constitution has been classified based on the requirements to be constituted as state. There are other parts like there are around 12 parts which can be constituted as miscellaneous parts. These parts include provisions for like say emergency, center-state relations, distribution of financial relations between center as well as state. So these 12 other parts, miscellaneous parts, will deal with all the other parts. Because of the inclusion of these miscellaneous parts, many people will call Indian Constitution as the bulkiest constitution, because our constitution makers has made sure that almost all provisions have been defined in the constitution itself, so that they give very much room for misinterpretation when it comes to Parliament of India. Clear? If there is less room for misinterpretation, there is less. Our Parliament is less prone to misusing the provisions of Constitution. So that's why they have taken a great care in defining all the provisions in constitutions. Clear? Now, if you look at the origins of constitutions, if you look at the origins of if you look at the origin of constitution itself, you have to date back to ancient as well as medieval times. In ancient as well as medieval times, king is a person who controls legislative as well as executive as well as judicial spheres of government. Clear? King is a person who made rules in a particular territory. King is the executive of that particular territory, and king is the judicial authority who can adjudicate between two parties. So all the powers of government derived from a single person called as king. Now this type of government is called as doctrine of divine rights. This type of government is called as doctrine of divine rights. Now, in 1600s, there was a new group of people called as merchants who were becoming very powerful in Britain. These merchants were becoming more powerful in Britain. Now they formed a body called as Parliament. They formed a body called as Parliament to represent their interests in the government. Now, this Parliament presented a document called as Magna Carta. At the height of their powers, Parliament presented this document called as Magna Carta during Glorious Revolution. During Glorious Revolution, which happened in Britain. Okay. During this Glorious Revolution, Parliament presented Magna Carta to the king. Now, what this Magna Carta did is that it restricted the powers of king. Okay. It restricted the powers of king. It said that king cannot do certain things. King cannot do certain things. King is allowed only to legislate on these amount of matters. Rest, all these restricted powers will be transferred to Parliament. So gradually, over a period of 200 years, Parliament gradually took all these powers away from the king. Clear? Parliament took away legislative powers of the king. Parliament took away executive powers of the king, and Parliament also took away judicial powers of the king. Okay. Parliament during 1800s took away all the powers of the king. So now Parliament is the authority out of which legislative branches, executive branches, as well as judicial branches derive their power from. Now, this type of government is called as, this type of government follows a principle called as doctrine of parliamentary. This type of government follows a doctrine called as doctrine of parliamentary supremacy. Clear? Now, why do you think this type of government is called as doctrine of divine rights, and this type of government is called as doctrine of parliamentary supremacy? Because in this type of government, king is a person which is very powerful. Okay? King, out of king only all these three organs derive their power. That's why this theory is called as doctrine of divine rights. But in case of this type of government, all these three branches of government derive their power from Parliament. That's why this theory is called as doctrine of parliamentary supremacy. Clear? Now this happened in UK. Now the next theory emerged in USA. The next theory emerged in USA. Clear? Now if you look at the origins of USA, British merchants, they went to USA and they occupied 13 colonies in USA. Clear? British merchants, they went to USA and they occupied 13 colonies in USA. Now, Britain taxed USA very heavily. They taxed USA very heavily. So, this dissolution on a lot of powerful people in USA. So, they wanted to declare USA as independent country. So, what they did was that these 13 colonies, they came together and formed a body called as, these 13 colonies, they came together and they formed a body called as Congress. Clear? Now this Congress has only military powers. This Congress had only military powers. Now these military powers can be used only to fight against British forces after after British forces has been successfully repealed. Military powers will be completely disbanded, and these 13 colonies will be completely independent of each other. So that was the original arrangement. But after American War of Independence, after American War of Independence, these 13 colonies proclaimed a document called as Declaration of Independence. These 13 colonies proclaimed a document called as Declaration of Independence, stating that they are from now on they are free of British occupation. Now, this Declaration of Independence mandated that these 13 colonies should establish a body called as Constituent Assembly for framing a social contract called as Constitution. Clear? This Declaration of Independence stated that these 13 colonies should establish a body called as Constituent Assembly so that they can frame the Constitution. Now, while framing this Constitution, this Constituent Assembly wanted to ensure three things in mind. Yeah, they didn't want to follow they didn't want to follow parliamentary government. Yeah, they didn't want to follow parliamentary type of government because even though parliamentary type of government is democratic in nature, still parliament is more powerful. Clear? They wanted to curtail the powers of parliament. Now they wanted to curtail out the powers of parliament because this constituent assembly, first and foremost, they wanted to preserve their fundamental rights. In US, it is called as Bill of Rights. First and foremost, they wanted to preserve Bill of Rights. Now, after that, they wanted to preserve states' rights as well. Clear? They wanted to preserve states' rights as well. Now, if USA implemented parliamentary form of government, Parliament is still very powerful. If Parliament is very powerful, what can it do? It can still take away the powers of fundamental rights. It also can take away the powers of states as well. So to prevent that from happening, they didn't want to follow parliamentary form of government. So instead of that, what they did was they divided all three branches of government into separate entities. Clear? They divided all three branches of government into three separate entities. That is, executive became a separate body, legislature became a separate body, and also judiciary became a separate body. Now, all these three organs were separated by a principle called as separation of power. All these three branches of government was separated from by a principle called as separation of power, and all these three organs derived their power from a body called as constitution. Clear? So constitution, one, it gave power to these bodies. Clear? It gave mandate to these bodies to govern this particular land. Second one, it also restricted their powers. Clear? It also restricted their powers. How does constitution restrict their powers? It clearly defines what is the power of legislature. It clearly defines what is the power of executive. So if constitution is clearly define all these powers, legislature cannot act beyond these means. Clear? Legislature cannot act beyond their means. If the legislature is acting beyond their means, what will other organs do? Judiciary will immediately curtail the powers of legislature. So if executive is acting out of their bounds, legislature will immediately curtail the powers of executive. Now this system is called as, this provision of curtailing powers of each other organs is called as checks and balances. Clear? So USA, by following constitutional form of government, first constitution gave power to these bodies. The next one is constitution restricted the powers of this constitution, and it introduced a principle called as separation of power. By ensuring the separation of power, it ensured a concept of checks and balances. Now this type of government is called as doctrine of constitutional supremacy. This type of government is called as doctrine of constitutional supremacy. Clear? Now, if we look at, now let's compare the differences between parliamentary form of government as well as presidential form of government. Parliamentary form of government as well as presidential form of government. So now see here, this type of government was followed in USA. This government was followed in parliamentary form of government was followed in UK. So for sake of comparison, here we will be comparing two types of government in UK as well as USA. Clear? We will be comparing both UK as well as USA. Now, if you look at the differences between parliamentary form of government as well as presidential form of government, in case of parliamentary form of government, head of executive is different from different from head of state. Head of executive is different from head of state. In case of presidential form of government, head of state as well as executive is the same person. Clear? Case of parliamentary form of government, head of executive as well as head of state is completely two different persons. Head of executive as well as head of state is the same person in case of presidential form of government. Clear? Since head of executive and head of state is different in parliamentary form of government, there is a possibility that in parliamentary form of government, it can follow either Republican or monarchical form of state. Here, in case of parliamentary form of government, it can either follow Republican or monarchical form of government. But in case of presidential form of government, it can only form Republican mode of government. Now, in case of head of state, when it comes to parliamentary form of government, this head of state, it can be either elected or it can be selected by means of lineage. In case of monarchy, it can be selected by means of lineage. Now, using this lineage, there are a number of countries who follow this type of model like UK, Nepal. All these are monarchical countries where the head of state is a king, not a person who is elected. But in case of presidential form of government, head of state is clearly elected. He is not selected by means of lineage. Clear? So these are the differences between parliamentary form of government as well as presidential form of government. Now, another crucial difference is that in case of parliamentary form of government, there is no separation of power. There is no separation of power between bodies. Clear? There is no separation of power between executive, legislature as well as judiciary, because all these three organs are coming out of parliament. But in case of presidential form of government, there is separation of power. Clear? So this is one type of classification in constitutions. There is another type of constitution in classification called as written constitution as well as unwritten constitution. Okay? So this is another type of classification. Now, in case of unwritten constitution, this follows a principle called as doctrine of parliamentary supremacy. This follows doctrine of parliamentary supremacy because this constitution is evolved over a period of time. This constitution is evolved over a period of time. As I mentioned before, Parliament gradually took these powers away from the king. So as they are gradually taking these powers away from the king, they passed number of laws, they made number of rules for governing UK. So this type of constitution is evolved over a period of time. So that's why this constitution is unwritten. But in case of written constitution, it follows the principle of doctrine of constitutional supremacy. This type of constitution is clearly written. Now, if you look at the amendment procedure for this particular type of constitution, in case of unwritten constitution, it can be amended by ordinary legislation. Clear? It can be amended by ordinary legislation because Parliament has almost all authority when it comes to framing the constitution. So that's why Parliament, by passing ordinary legislation itself, they can amend the constitution. But in case of written constitution, it follows rigid amendment procedure. It follows rigid amendment procedure. Clear? But in case of written constitution, it has to be enacted by a separate body called as Constituent Assembly. It will be passed and framed by a body called as Parliament. Clear? So these are the two differences between a written constitution as well as unwritten constitution. Now there is another type of constitution called as classification of constitution called as rigid constitution as well as flexible constitution. Clear? Rigid constitution as well as flexible constitution. In case of flexible constitution, it follows the principle of doctrine of parliamentary supremacy. In case of rigid constitution, it follows the principle of doctrine of constitutional supremacy. Or in case of flexible constitution, it can be amended by means of ordinary legislation. But in case of rigid constitution, it can be amended by means of only rigid procedure by means of special majority. It can be amended only by means of rigid procedure by means of special majority. But for amending in flexible constitution, it can be done so by means of passing in ordinary legislation itself by means of simple majority. Here, by means of simple majority. And in case of flexible constitution, it can either be written or unwritten constitution. It can either be written constitution or unwritten constitution. But in case of rigid constitution, it has to be a written constitution. Okay. So this is one type of classification: rigid constitution as well as flexible constitution. Now there is another type of classification called as unitary constitution as well as federal constitution. Now before going into the topic, first you have to understand what is a federal constitution. Now without understanding what is a federal constitution, you can understand the differences between unitary as well as federal constitution. Now if you look at the principle of federalism, now federalism can be defined as any form of government which has two or more layers of government. Any form of government which has two or more layers of government. For example, in federal government there will be central government, there will be state government, there can be also local self-government. Now if there is only central government as well as state government, this constitution will be called as two-tier federal structure. If there are three federal units, it will be called as three-tier federal structure. So that's the definition of federalism. But there is a crucial difference between federalism as well as unitary government. See, even in case of UK, France, even in case of UK as well as France, there is a state government. Clear? So even though in UK as well as France there are state governments, equivalent of state governments, UK as well as France are not called as federal government. Now these countries are not called as federal government because in case of UK as well as France, state government derive their power from central government. Okay. Central government is the authority which is giving power to these state government. So state government will come under the authority of central government. State governments don't have any real autonomy. But in case of federalism, central government as well as state government, these two are completely independent entities. Clear? These two has to be separated by a principle called as division of power. Clear? These two entities has to be separated by means of a principle called as division of power. Now this division of power divides the power between central government as well as state government. Now, importantly, this division of power has to be guaranteed by a document called as Constitution. Clear? So instead of state government deriving their power from central government, in case of federal government, both central government as well as state government has to derive their power from Constitution, and Constitution should also divide their powers accordingly by means of division of power. Okay, so that's the difference between unitary government as well as federal government. The crucial difference between these two governments is the principle of division of power. So if you look at now looking at this diagram, you can tell what are the features of federalism. Okay, you can tell what are the features of federalism. If you look at this diagram, what does it say? These two entities has to be kept independently by means of a principle called as division of power. This division of power has to be guaranteed by a document called as Constitution. So that's why, in case of the first requirement for a country to be a federal country is it should have written constitution. It should have a written constitution, and this written constitution should guarantee division of power between. This written constitution should guarantee division of power between these two federal structures. And if we now, even though constitution has clearly divided powers between these two organizations, in certain cases there will be disputes arising between these two federal units. For example, central government in 2008 introduced NIA, created a body called as National Investigative Agency. Now, this National Investigative Agency can take up any cases from state government if that case is involved with terrorism. Clear? See, police as well as law and order will come under state subject. These are the domains of state government. But if a particular case is involved with terrorism, NIA has a mandate to take away these cases. Now, while passing this National Investigative Agency Act, central government did not consult with state government. So, number of state governments went to Supreme Court and filed a case. Clear? So now, if the state government is going and filing a case in Supreme Court, if Supreme Court is coming under central government, do you think Supreme Court will act impartially? If Supreme Court is coming under state government, if there is a dispute between central government as well as state government, do you think Supreme Court will act impartially? It won't act impartially, right? It will act in favor of central government. So that's why, in case of federal country, judiciary should be independent. Judiciary should be independent. Here, if judiciary is coming under central government, judiciary will not act in the interests of state, will not act impartially. So that's why judiciary in a federal country should always be independent. And lastly, financial powers of state government should be provided in Constitution itself. So, for example, if all the financial powers are vested with central government and state government are dependent on central government for their financial resources, state government can use this advantage to stifle the powers of state government. So that's why in a federal country it is very important that financial powers of state government is clearly defined in the Constitution itself, so that there is no dispute between central government as well as state government. Now in India, financial powers of state government is mentioned in Article 270 as well as 271. Okay. Now take a look at all these principles, all the features of federalism. Do you think all these things applies to India? Look at the first provision, written constitution. It applies to India as well. Division of power, yes, it applies to India. Division of power is provided in 7th schedule, where 7th schedule demarcates number of areas into union list, state list as well as concurrent list. Clear? Does India have independent judiciary? Yes, in India judiciary is independent of executive as well as legislature. What about having financial powers for state government? Yes, constitution provides for financial powers of state government, which is mentioned in both Article 270 as well as Article 271. Okay. Now, keeping this in mind, in this type of classification of constitution, unitary as well as federal constitution. There is only one L. In this classification of constitution, unitary as well as federal, what are all the differences here? In unitary constitution, there can be either written or unwritten constitution. In case of federal constitution, it has to be written constitution. Here, now this unwritten constitution follows a principle called as doctrine of parliamentary supremacy. This follows a principle called as doctrine of constitutional supremacy. In case of unitary constitution, the amendment procedure can be flexible, but in case of federal constitution, the amendment procedure should be very rigid, because if the amendment procedure is very flexible, central government can have the power to take away all the powers from state government by means of amending the constitution. So that's why whenever, in case of federal country, whenever they are amending the constitution, getting approval from states is very, very important. Okay. The next one is it can have either independent or dependent judiciary. Clear? In case of unwritten constitution, the judiciary can either be independent or dependent. But in case of federal constitution has to be always independent. Okay. So these are the different types of classifications that I have mentioned here. These classifications are primarily based out of countries like UK as well as US. But if you look at the case of India, what India has done is that they have combined both the aspects of UK as well as UK while making Indian constitution. While India is parliamentary form of government, India has also a written constitution. In case of UK follows parliamentary form of government, but in UK there is no written constitution. But in India, even though we are following parliamentary form of government, there is a written constitution. In case of India, we are both federal as well as unitary country. In case of India, we both have rigid as well as flexible amendment procedure. So when it comes to Indian constitution, we have mixed both UK as well as UK constitution when framing the Indian constitution. Clear? So the structure of our Indian constitution goes like this. If this is constitution, the head of our state is president. Clear? In our constitution, there is Lok Sabha as well as Rajya Sabha, as we are following parliamentary form of government. Since we are following parliamentary form of government, executive is taken out of legislature. Now executive works under President of India. Now this diagram is called as Union Executive. Union Executive. Okay. Now this diagram is called as Union Executive. This will come under Union Legislature. Okay. This will come under Union Executive. This will come under Union Executive. So what does this imply? In India, since India is a parliamentary form of government, Union Executive will be taken out of Union Legislature, and importantly, President is part of both Union Executive as well as Union Legislature. Now, there is Judiciary, High Court as well as District Court. Now, in case of legislature as well as executive, in India there is no separation of power between these two organs. But when it comes to judiciary, India follows separation of power between judiciary and other two organs. Judiciary is kept independent of other two organs. So unlike USA, only judiciary is kept independent, not executive as well as legislature. Clear? This principle is called as separation of power. Clear? In India, only judiciary is kept independent, not executive as well as legislature. But India also has state government. Now, state government is represented by a person called as governor. Now, this governor is a representative of President of India. Even in state government, there is two legislatures called as State Legislative Assembly as well as State Legislative Council. Now, the State Legislative Council is optional. So, out of state legislature, we will take state executive. Now, this is state executive. This is state legislature. Here, now this is state executive. This one is state executive. This one is state legislature. So, looking at this diagram itself, we can infer that state executive is a part of state legislature, and governor is also part of both state executive as well as state legislature. Now, there is a thing which divides these two forms of government. Now, this division is termed as division of power. Clear? There is a division of power between central government as well as state government. This division of power is called as division of power. This division of power as well as separation of power, these both are guaranteed by the Constitution of India itself. Clear? Now, look at this diagram. Now, tell me whether Indian Constitution follows doctrine of parliamentary supremacy or doctrine of constitutional supremacy. India follows doctrine of constitutional supremacy because all three organs of government, that is judiciary, executive as well as legislature, they derive their power from Constitution of India. In India, Constitution is supreme, not any other organ. In case of UK, Parliament is supreme. In case of USA, Constitution is supreme. Even in case of India, Constitution is supreme. Clear? Now, there is division of power only when it comes to executive as well as legislature, but there is no division of power for judiciary. In case of USA, there is division of power for all three organs of government, but in case of India, there is no division of power for judiciary. In case of judiciary, in India, judiciary is integrated. So, that's what I meant about. In India, we have mixed both UK as well as USA. So, in this diagram itself, you can see that India has both federal as well as unitary features. Federal features include division of power between executive and legislature. Unitary features include integrated judiciary between Supreme Court, High Court as well as District Court. So, this is how Indian Constitution has been organized. So, that's it in this class. I hope I've taught you well enough about all topics, all information on origins of Constitution, what are the classifications of Constitution and the structure of Indian classification itself. Now, if you like this video, don't forget to like, comment as well as share this video. And if you want to if you want to see more videos like this, don't forget to subscribe to Unacademy's YouTube channel as well.